I think we'll get started. I think there's still a few people just coming back. But good morning. Welcome to the second panel, the rise of class actions. I think the relevance of class actions was quite well demonstrated by the first panel discussion. I think there were several mentions already of class actions in the course of the day. So I'd just like to introduce the panel. First of all, on the far end, we have Sindhu Sivakumar, who is a senior investment manager at Innsworth. In the middle, we have Neill, co-founder, director, and chief investment officer of Therium Capital. And nearest to me, Victoria Wakefield, QC, leading counsel at Brickcourt Chambers, wide-ranging practice, but very relevantly to today's discussion, a direct involvement in both Merrick's and MasterCard and Lloyd and Google. I'm Neill Shrimpton, a partner, head of litigation at Brown Rudnick. So why class actions? I think the relevance of class actions to litigation funders is obvious. The ability to bring together hundreds or even thousands of claimants allows you to generate an aggregate claim value that unleashes, potentially very attractive returns for funders and, for that matter, for lawyers who are willing to take some risk. The challenge, and we'll come to this later in the panel, is managing the case in such a way that the costs of managing those hundreds or even thousands of claims remains proportionate even in the context of returns that are potentially in the tens or even hundreds of millions of pounds. So when we talk about class actions, what do we mean? I think what we're really referring to are the mechanisms and procedures for managing those hundreds and thousands of claims through to an efficient and effective resolution. So in the course of this session, we're going to talk about various of those techniques, some topical issues arising from recent case law, some of the challenges that need to be met in the management of class actions, and then finally we'll talk about some of the cases, some of the class action cases that the funders on the panel are particularly attracted to at the moment. So first of all, if we could just start by talking about some of the class action mechanisms that are available in this jurisdiction. Perhaps, Neill, could you start by just talking about the GLO mechanism, representative actions and ad hoc groups and how they operate and the type of cases that they would be attractive for?
Sure. So it's easy in this space on talking about class actions to get caught up in the sort of procedural excitement of opt-out classes and CPOs and the cat and so on, and we'll come to that, it's very important. But most of group actions have been run now for many years on an opt-in basis, using either the GLO mechanism or ad hoc groups. So I think since 2000 there have been 109 group litigation orders made, covering a multitude of different types of cases. This, for instance, would cover the post office litigation that was brought on behalf of the sub-postmasters, achieving a result for them overturning, I think, what was said to be the largest miscarriage of justice in British legal history. So that was a group litigation brought on an opt-in basis, using a GLO. Similarly, we also got the Volkswagen litigation, which is now, I think, around 90,000 people who are within the GLO, plus a whole raft outside, which again, I think that makes it the largest opt-in GLO group running at the moment. And we've got, I think, the application made for the next GLO in the next emissions case, the Mercedes one. It's not public yet about where the numbers will come out on that, but I would imagine that they will come out at least the level of the Volkswagen case. So we have a very effective mechanism available to collective redress lawyers to bring opt-in cases and increasing sophistication in how those groups are brought as well. I mentioned, aside from the GLO cases, there are also a raft of cases that are brought without any form of procedural mechanism whatsoever. So, for instance, if you looked at the Ingenious litigation that settled last week, just at the beginning of a 6-month trial, that again was an opt-in case. There were 3 different groups of lawyers representing a number of different groups of clients. A very substantial case by any measure. No GLO whatsoever, all done with cooperation between the lawyers and proactive case management by the courts. So there's no need for any of these mechanisms at all. The courts have all the case management powers. And I think very interesting in that type of example is to look at the interchange litigation that's going through now, the CAT, which was a raft of different cases brought both in the High Court and in the CAT, where the cases are now being brought through and transferred into the CAT, and the CAT is now proactively managing them as a group to try to get efficient resolution of the cases. And the common issues resolved there. That has the CMC on Monday, so it'll be very interesting again to watch how the CAT grapples with that problem on an entirely ad hoc basis without any form of CPO. So ad hoc and GLOs, two major ways in which these large cases are being run. I should mention the third one, which is the CPR 19.6. Now, this is a very long-standing procedural rule that allows representative actions. It's that sort of hidden class action, if you like, in British procedure, English procedure. Traditionally, of course, for clients who have the same interest, so one will bring the case and the others will be able to benefit from the outcome of that case because they have the same interest. This was the subject of Lloyd and Google, and I know we'll talk in much more detail about it, but I think that Lloyd and Google decision opens up some quite interesting creative uses of that procedural mechanism, which I think hitherto has been a very narrow and rather underused mechanism.
Thank you. Sindhu, would you mind just speaking briefly about the collective procedure orders in the Competition Appeal Tribunal?
So you've got collective proceedings before the CAT. These are proceedings a bit like 19.6. You've got the proceedings brought on behalf of a class of persons by a representative. The difference is they are for competition law infringements only. So they narrow in subject matter scope to some of the other processes that Neill's just gone over. They can be standalone or follow-on, and they can be standalone in the sense that infringement has to be proved, follow-on, so following on from a finding of infringement by a specified regulator. And they can be opt-in, where class members actively sign up to be part of the group, or interestingly opt-out, where everybody within a defined class is automatically part of a group unless they actively choose to opt out. The CAT opt-out is probably the closest thing that we have to what is traditionally thought of as a class action, the US-style class action. The thing with the CAT is these collective proceedings are quite heavily regulated by the CAT. The CAT has to decide whether or not to allow a collective proceeding to proceed as such, whether it's opt-out or opt-in. And in making these, how it makes these decisions is currently subject to a lot of litigation. So it's a novel process, and the law and far from settled.
Thank you. So we've heard there a few references to opt-out, opt-in. I'm sure most people in the room are very familiar with those as concepts, but I think generally speaking, to the extent it's possible to generate an opt-out proceeding, that would be regarded as most beneficial. That allows the claimants, the funders, to assemble a claimant class, which is identified by reference to certain criteria without the need to actually go out and identify the individuals that fall within those that description. There's been some recent high-profile decisions with regards to opt-out procedures. So Victoria, first of all, would you mind addressing Merrick's and MasterCard and Lloyd and Google, what the implications of those decisions have been for opt-out procedures, and obviously what the implications for funders in those types of proceedings would then be?
Of course. So both the CAT regime, the CPO regime, and the 19.6 regime have recently been the subject of two Supreme Court decisions, one in Merrick's and MasterCard and one in Lloyd and Google. And I appeared for the claimant in both of those. And there are some commonalities for those two cases. In particular, there are massive groups of claimants. In the case of Merrick's, 45, 50 million claimants, and in Lloyd and Google, about 5 million claimants. And the damages on a per capita basis are pretty low, hundreds of pounds, nothing more. And there are massive efficiency and cost savings in grouping everything together. So these really are quintessential mass class actions. If I start with Merrick's, which is, as I'm sure you all know, the CPO case. So Merrick's is an interchange claim. It relates to the fee charged by banks to merchants which accept MasterCards. And following on from what Sindhu said a moment ago, it's a follow-on claim. So it's very attractive in the sense that liability has already been established by a commission decision, and all we're doing is arguing about causation and quantum. It's a very long infringement, 16 years, between 1992 and 2008, and that's one of the reasons why the quantum is so massive and the class is so massive. The class is a consumer class, and that's something which we may touch on later in this session. So the way that the consumers suffered loss, very briefly, is that the merchants paid the interchange fee, unlawfully elevated as it was, and we say that the merchants then passed on that loss to all consumers in their shops. So not just the ones that use MasterCards, but everyone who bought goods or services from those merchants. As I said when I started, around 45 million consumers are affected by that claim, so they suffered loss over that period and they're still alive. Now, critical to the claim is the availability of aggregate damages. One of the big statutory innovations in the CPO regime is the availability of aggregate damages. That means that you never need to look at individual loss, and instead you calculate loss to the class as a whole. And in Merrick's, we're doing it on a top-down basis. So we're working out the total overcharge across the economy as a whole, working out pass-on through all of the sectors of the retail economy, and then working out total loss to the entire class of UK consumers as a whole. And that gives rise to a total aggregate award, we say, of around £16.5 billion. So it's around 7 billion of pure quantum and then around 9.5 billion of interest on top. Now, one of the important things about the CAT regime, as Sindhu said, is that it's heavily regulated. So we have the primary legislation, we have rules, we have the guide, and we have a rapidly accreting set of case law telling us how the regime should work. And that's particularly important because it's so different from 19.6. 19.6, we just have the rule, and we have quite a lot of cases. We now have Lloyd and Google, but otherwise it's all from first principles. The CAT, in contrast, very heavily regulated. Before I move on to the Supreme Court judgment, I should note, because it's of most obvious relevance to the audience today, how it is that that prescriptive regime allows for the funder's return to be paid. Now, in Merrick's, at first instance, it was argued that there was no ability for the funder to be paid any return on their investment under the regime. That just wasn't possible. And the CAT said, no, that's wrong, and that funders are pivotal to the regime. They went back to the statutory materials, the parliamentary debates, and said plainly the regime only works with funding. And then they looked at the ability in the statute and in the rules to make a payment out of undistributed damages of the class representative's costs. And they then held that costs include not just inter partes costs, but also just the everyday linguistic costs of being there. And so it was under that power that they were going to award the funder its return in due course. Now, I think we may come on to talk later about Le Patorel and how things have developed most recently with that. But that's where the CAT said initially the investment return should be recouped from. And the CAT also said, as Nick Bacon adverted to in the earlier session, that it had the power to set the ultimate return at the very end when it comes to the distribution process. There's undistributed damages, the return's going to come out of the pot. And one of the arguments in Merrick's first instance had been, CAT, you don't have the expertise to do that. If that's your function, how are you going to do it? And there's a paragraph in that first judgment in which the CAT said, well, we'll do what happens in arbitration claims, where the costs of funding are part of the arbitral costs, and we can hear evidence about the market and about what the right rate of return is. So we say we do have that power, but we are going to exercise it. So that's very interesting. That's at first instance. It wasn't appealed. It didn't go up. So the Supreme Court judgment in Merrick's, I think for our purposes today, in a sense, the most important thing about it is that the Supreme Court had in front of it a suite of different options or ways in which it could interpret the regime. And it chose a way of interpreting the regime that was extremely claimant-friendly, or at least that's what all the defendants would say. So when it was looking at the threshold, the gateway for making a CPO, that first stage of constituting the proceedings, it really anchored itself in an interpretation of the regime which is pro-access to justice, pro the bringing of collective proceedings. It says, as is well known, that provided you withstand a strikeout test, which in any event would have to be brought separately, the strikeout application, you have an entitlement to have your case tried, and provided, essentially, that it's beneficial to have it tried collectively as opposed to individually, you should go ahead. That's a gross simplification of the judgment, but that's essentially where it came out. So a very facilitative, very liberalising reading of the regime, and that's one of the most important things that it has for that regime going forward. Lloyd and Google were away from the CAT, away from competition, away from the bespoke regime, and we're in 19.6. And as Neill said, historically, it's been very little used. It was used extensively historically and into the 19th century, but historically over the last century, not so much. And it was really the sort of thing which, as a barrister, you'd rely on if you were suing on behalf of a golf club or allotment owners, that kind of thing. Representative action, very, very small. In Lloyd and Google, we decided to deploy it on a mass opt-out basis. Now, because the regime is on the basis, or was until the Supreme Court, on the basis that there has to be the same interest between the litigated claims and all the other claims, it was necessary to make them identical. It's a data breach claim, and the way that we made all the claims identical was suing for what we called the lowest common denominator. So we chopped off all the top bit of damages, and we also had to sue for a particular kind of damages, a kind of damages where you don't need individual evidence in order to be entitled to them. And we said that all 4.5 million people had suffered those same kinds of damages by Google unlawfully exploiting the browser information. Each of them would have a per capita amount, and you add it all together. So immediately you'll see it's not the same kind of aggregate damages that we're talking about in the CAT. It's instead per capita, and you add it all up together. Now, as is well known, Lloyd and Google in the Supreme Court, they said, well, your starting position in data protection is wrong. That kind of damages that you're suing for is not available. So that's the big takeaway for data breach claims, at least under the old Act. That kind of damages, you just can't do what we were trying to do with it. But very interestingly, for today's purposes, we have a very strong judgment of the Supreme Court endorsing the use of 19.6. So we have the same access to justice reasoning coming through Lord Legate's judgment as we have in Lord Briggs's judgment in Merrick's. We have an endorsement of it being used with associated machinery, court-made machinery, so an opt-out process. Lord Legate says, well, you could even use it on an opt-in process. He says as well, you don't need this narrow same interest that everyone had thought you did need. And in fact, you can have all different kinds of claims brought together, provided there's no conflict. And the representative can raise issues that aren't raised in his or her claim and can be trusted with the assistance of their lawyers and funders are name-checked in the judgment as a force for good, to make sure that all necessary issues are ventilated. So a very liberalising and positive judgment. But then, of course, we come to, well, damages. It had been said against us, you can never sue for damages in representative action. Lord Legate says, no, that's wrong. You can sue for them collectively, en masse, provided you don't need to go into individual detail. And he gives some examples. So bottom up, he says, well, what about a fee that's been wrongly charged to everyone? Or what about a product where there's a product liability case, essentially, and the asset's been impaired by the same amount across the class? He also endorses a top-down approach in some limited circumstances. He says, well, there are insurance claims where it doesn't matter where in the syndicate the loss would ultimately lie. And at the end of the judgment, he says he's prepared to accept without deciding that our idea of lowest common denominator might work. So if you can think of a type of damages where you don't need individual proof, That's still on the table. So those are all available, pure opt-out, and it would give rise to a pot of damages at the end. But then extremely unhelpfully, he says in passing, well, query whether the funder would ever have a legal entitlement to be paid out of those damages. So obviously, task number one, go back to court and find out whether funders do have an entitlement to be paid out of those damages. But we know that we do have that regime now working on an opt-out basis. And he then, and this is my final point, develops an idea of a bifurcated process. So a bifurcated process is one where all the issues that can be determined collectively in common on an opt-out basis are determined that way. And then your class members become claimants, essentially, at the damages stage. And at that point, they can adduce whatever individual evidence is needed. Now, there are an awful lot of questions still outstanding about quite how that works, how it's fundable. There's massive scope for creative thinking, for first mover advantage, but plainly he thought that there was something in it, and he did do some helpful things to promote it. So one of the things he did was he changed the limitation position. It'd always been understood that the reason that didn't work would be because the limitation would run for the damages claims whilst you were having liability determined. And he said, no, that's wrong, and that time stops running for all purposes when the first representative claim is brought. So he's helped a little, or a lot even, but there are many more questions which still are unanswered, but exciting times, I might say, for people who want to put on their thinking cap and think of the best way of exploiting those very helpful indications.
Thank you. Neill, the recent FX decisions in the CAT, what are the implications of that as to whether future proceedings are likely to be on an opt-in or an opt-out basis?
Sure. So this is an application for an opt-out CPO in the CAT. We've seen obviously a raft of CPO decisions for consumer groups, Le Paturel and Gutman and so on. This is the first one, to my knowledge, that's come in front of the CAT, which is for loosely business claimants, so people who had traded FX with banks, typically funds, pension funds, hedge funds, and so on. So commercial parties rather than consumers. And it's important for two reasons. One is it's the CAT considering whether to grant an opt-out CPO in that context. And secondly, it was also the first case with a carriage fight. So on the opt-out side, first of all, the CAT actually refused the opt-out class in this case, but did indicate that it would allow an opt-in class. And there were two real drivers for that. The first one was a view about the strength of the case. Now, notwithstanding that this was a follow-on case, the CAT was not satisfied with the pleading of the case by either of the two sides, and therefore felt the case was potentially susceptible to strikeout simply as a result of the pleading. And on that basis, because of the strength of the case concern, that was a factor that mitigated against granting an opt-out CPO. So that was the first reason. The second reason, though, and it's relevant to the business side of this, is that the CAT considered whether or not it was practicable to run the case as an opt-in case. And here they noted that, you had a sophisticated group of clients, so who could potentially understand whether to get involved in litigation, understand and consider that question. And B, you had, so not only were they sophisticated, but they had actually been marketed to. So there was evidence that the claimant law firms had actually approached potential clients and sought to run the case on an opt-in basis, but been unable to do so. So it was accepted, I think, by everyone in front of the CAT that it wasn't possible to run this case on an opt-in because there wasn't client appetite to do so. But that lack of client appetite counted against the opt-out applications, and therefore the CAT said, no, that's a reason to not allow the opt-out, we'll allow it only on an opt-in basis. So that's pretty tough. So that means if you go out and heavily market to the client base, and the client base, for one reason or another, don't wish to take part, then that might actually be a factor why you can't get an opt-out class and can't bring the case at all, opt-in or opt-out. So that's a pretty tough decision and quite interesting. The second aspect of this case was the carriage fight. So as I say, this was the first where you had two competing representatives wanting to be the class representative, and who were both applying for an opt-out class, and therefore it was cutthroat. Only one of them could succeed. The CAT, what we'd really hope, of course, from this is we expect to see this dynamic much more commonly in the future. And you see it, there was a real rise of this in Australia a few years ago. No doubt the same thing may well happen here. And so what would be nice would be to see some clear direction as to how these carriage fights will be resolved. But there is a slight flavour from the CAT's decision that actually it didn't really like this sort of unseemly process at all, and it regretted the fact that the representatives hadn't been able to find common ground between them, as they put it. In the end, they looked at various factors between the different two representatives. The fact that one had more funding and more AT than the other was a factor in their favour. But in the end, they ignored all of that and concluded the two were very similar. And they marginally preferred the efforts of one to what they described as capture an elusive loss, perhaps faint praise to either of them on that front. And so they preferred that one. So it was a sort of merits test, really. They looked at the strength of the case and compared those two. So it's not really clear at the moment how, that perhaps is an exceptional case. And so it's not really clear how the CAT is going to address carriage fights going forward. So we don't really have a great deal of clarity on this. I should say that both representatives have indicated an intention to appeal, so hopefully we will see these issues further developed. And there was also a very strong dissenting judgment as well. So again, that's worth looking at in terms of how it went. The dissenting judgment suggested that the Paul Lomas would have granted the opt-out CPO. The other footnote to make on this point is that we're also waiting for the decision on trucks, where we have again two representatives, one on a pure opt-in basis and one opt-in or opt-out. That should probably come down later this month, and then again that will give us a bit more guidance. But at the moment, it does look like where we are on opt-in or opt-out for business cases is unclear, and where we are on carriage is also pretty unclear too.
If I could just add to that, I should say that we are for competing class representatives in FX. I'm for the marginally preferred one, I should say. But I would say going forward, my prediction would be that carriage will be determined much earlier. I think that was a mistake. And as I'm sure many of you know, we all went to the CAT at the beginning of the process, common ground between us and between all of the defendants that it should be determined at the very start of proceedings. Otherwise, there's a massive wasted costs. And in the face of that commonality across all council teams, the CAT decided no, and instead it wanted to wrap carriage up with the very end of the process. So it essentially heard two competing CPOs and decided at the end of the process. And I do think that will be revisited.
Yeah, I'd also add, actually, think on this kind of carriage point, one of the features of this was because the strength of the case and the expert evidence was important, you had a situation where you had each claimant potential representative cross-examining the other representatives' experts and trying to discredit them or discredit their theory, which I think is an extremely unhelpful dynamic, and you can see where that ended up with the CAT liking neither. So, solitary lesson, I think.
Yeah.
Sindhu, anything to add on the likelihood of opt-out or opt-in going forward?
I mean, one thing that's interesting is, what happens with businesses, as Neill said, is the opt-out regime just for consumers, or is it going to be available for sophisticated institutions as well? I mean, FX is the majority's opinion is it's not helpful on this. I mean, the fact that the majority of the class, at least by claim value, were sophisticated institutions did seem to influence them. But I mean, it seemed like there were other things going on as well, right? The view that the average individual losses, we can debate whether that's the right way to look at it, were high, and also the previous attempted book bill that took place. The dissent, I think, on this point expressly stated that there's nothing in the Act or in the rules to suggest that the opt-out regime should not be available for large businesses, or indeed even for large loss holders. So that, I think we'll just have to see how this plays out in appeal. I mean, interestingly, was it just before FX, or I think a little before, there was the car shipping cartel, where I think at least half of the class, by value at least, were large, sophisticated businesses, and in that case, an opt-out was granted. So I think it's ambiguous, it'll be interesting. I mean, I don't know if until the appeals are decided in FX, will the market feel comfortable funding or putting forward another opt-out with primarily large institutions? We may just have to wait for the appeals.
Okay, thank you. I'm just going to turn now to some of the practical challenges of group actions and how we might deal with them. Neill, if I could come to you first, we've already mentioned that some of the most significant challenges relate to book building and budget management. Can you just explain what those challenges are, and do you have any ideas as to how you best manage them?
Sure. So, I mean, you can see from the landscape of this with opt-in cases, book building is extremely important. Actually, I think that it's a challenge in the sense that it needs to be done effectively and it needs to be done cost effectively. So you need to be able to get the group size up, and ideally a significant proportion of that group, and it needs to be done at a cost which is economic for the case. But actually, I'm pretty optimistic on this front. We've moved on a long way from the way, for instance, the VW group was done, which was done very effectively. I think the VW group is about 7.5% probably of the total market of the car owners that were eligible, which is a pretty high percentage when you think that they were opting in, and they were opting in back in 2017 when all of these sort of mechanisms were extremely new. But we've gone a long way from that. If you look at the effectiveness of some of the ways in which these groups are being done now, they are being done much more efficiently. You're getting much greater sign-up, and it's being done at a much more reasonable cost. So I'm pretty optimistic on that front. But it is an essential part of making any of these cases work. It's also horses for courses. What works for a consumer group when you're trying to market to Mercedes car owners is completely different to if you're marketing, of course, to institutional shareholders for securities case or the FX claimants, the funds in there who perhaps have a £50,000 claim and are a multi-billion pound fund who wouldn't get out of bed for a claim many times that.
Thank you. And Sindhu, just the experience of litigating in the CAT generally, and in particular the time that it takes.
I mean, duration is a factor you have to consider when going in for a CAT process. And in some ways, I think the delays we've had to date are primarily because it's such a novel procedure. So it's inevitable, really, that points of law are appealed and settled, and that takes time. And I think that's going to remain the case for the years to come until at least one or two of these cases, go through the full process. Now, what's encouraging, though, I think, is the time to CPO seems to be getting better. BT, I think, as well as Kent versus Apple, it took just a year, or maybe a little less than a year. That's an encouraging sign.
I would say that I agree with that, but in Merrick's the first time round, we went quickly to the first judgment. We issued in September, CMC November, we had the CPO hearing in January. He then sat on the judgment for a while, but we still got it in a few months. And then obviously 4 years later, we're in the Supreme Court. So I think a difficulty is that CPOs can be appealed. Yeah. And there was, that was one of the many issues that was determined in Merrick's at the outset, and it was said there was no right of appeal, and the Court of Appeal said yes, it fell within the narrow statutory language. But I think once the CPO stage has been overcome, and absent any application for strikeout or variation of CPOs, there isn't another natural point for an appeal until judgment. So I hope that once we're over the CPO point, we can go straight through to the end and then up again.
I mean, that's right, isn't it? I mean, we have seen them get quicker. So the Microsoft App Store case, I think the CPO was granted on the day.
Yeah,
so that's vastly better.
Yeah.
But I'm concerned about the opportunities for appeals, and obviously bearing in mind that the DBA question is going to the Supreme Court now in trucks, which I don't think anyone would have expected that. So I'm sure creative defendant lawyers will be coming up with new ways of blocking us up in the Court of Appeal or beyond.
Yeah.
Neill, carriage disputes have already been mentioned. What risks do they present to funders?
Well, very substantial is the answer to that. I think I mean, amongst the funding community, I think the idea of going into a case, spending a number of millions of pounds on it and then coming away with nothing is pretty off-putting. So I think there's going to need to be clarity about how this is going to work, and funders are going to need to be able to see that they are, either they have a clear advantage going into the carriage fight, and that'll be a very clear advantage, or they're going to need to be able to see they're going to be able to resolve this. I mentioned the Australian situation before. A few years ago, we saw, with common fund orders, we saw a trend in Australia towards contested common fund order applications, whereby you had these kind of cutthroat applications. I think the high point was probably 5 in AMP. You had 5 different groups fighting it out. And what you saw is after hitting that sort of apex of that, then there was a sort of common sense regime. An awful lot of people got a bloody nose and were unhappy about it. Some retreated from the market. And then you saw more combinations of funders and you saw deals being done. And so there was perhaps less head-to-head fighting because people realised that they just weren't up for that. So perhaps I think we'll end up more in that situation going forwards. And I'm not sure, as I say, looking at the CAT's comments on this, I'm not sure the courts would be unhappy with that. I think it would be quite fine to see this go away.
And so, Victoria, given all of those risks, what does that mean in terms of the sort of commercial viability of these claims? You know, what quantum do we need in order to make them worthwhile going forward with these risks?
Well, this is something that you guys are going to understand a lot more than I do, but in the advices I give and the cons that I have at the moment, it's apparent that people are needing increasingly punchy numbers to come close to funding. I mean, definitely several hundreds of million, probably a bit more than that at the moment. So that's changed. And it hopefully will be the case that as the carriage issue is resolved, that helps. But as we fight a fire somewhere, another one breaks out. So one of the unhelpful aspects, of the many unhelpful aspects of FX, was the tribunal's finding that we'd both grossly underestimated the defendant's costs, for example, even though I had 25 million or something, you had 35 million ATE, something like that. And the tribunal said not only that wasn't enough, but it didn't come close to the defendant's costs for fighting. So if they're thinking that in a follow-on claim, the defendants are going to have recoverable costs of 50 million, it's really astonishing, really, when you think about the sort of numbers you need to look at commercially for those.
Thank you. I'm conscious that we're running out of time, so maybe go to our conclusory section. Perhaps Neill and Sindhu, would you mind just giving us a view based on all of that? What are the types of group claims that you are interested in funding, that funders should be interested in funding at the moment?
I think it all depends on one's approach to risk and the resources available, right? But notwithstanding the discussion that we've had on FX and all the challenges of the opt-out, I think opt-outs are still very attractive when you look at the potential upside. CAT opt-outs are additionally attractive, because of the incentives they create for defendants to settle, because the undistributed damages don't go back to them; they go to charity according to the rules. On the downside, they're novel procedures, and you've got to have the appetite to take on all of the uncertainties and costs and delays that come with that. Group claims, right? GLOs and just lots of claimants on a claim form, I think can be interesting. The main thing, as Neill said before, is you've got to factor in the additional book bill costs as well as just claim management, whether it's practical or not. But the reality is these are the only processes available for lots of types of claims, securities and big interesting ones, right? Like securities claims, for example. So I think if you can find an efficient structure, whether that's having a manageable book size, whether that's high individual losses, whether that's efficient book build solutions or claim management platforms, they can be equally interesting.
Yeah, I agree with that. I think from my point of view, I think these all have a place. It just depends on the kind of case and the kind of dynamic. I think for the opt-out cases, they're fantastic when there's a very large claimant class and where ideally consumers at the moment, and where there's a very large amount of money at stake. Then the budgets work, the adverse costs are bearable, the risk perhaps around carriage is okay. And so you can go for that. But there are issues around them. You've got the certification issue as number one, and you've also got the question about how the CAT will think about returns at the back end, and we've no idea how that will come. So there's some risks in that, which means that there's an awful lot of benefit to doing cases on opt-in basis. You sign your people up, you know that you've got the claimant group, you know what the economics will be because you've agreed them in a contract and no one's interfering with that. So, and if you can do the book build at a manageable cost and providing the damages are at a level that it's economic to book build, there's I think a lot to be said for that mechanism as well. So, as I say, I think both have their place, and opt-in and the CAT in obviously as a sort of hybrid. I think the exciting one is 19.6 and the potential that we can make of that. And I see that both in those few cases where we could do it on a top-down basis, where the damages can be calculated on a top-down basis, and therefore you can get all the way through, providing we can persuade the courts that the funder can get a return. You hope that's a threshold point. But perhaps more relevantly, I think in the bifurcated 19.6, where it's a case that we'd be quite happy to book build anyway, but we can use the 19.6 procedure in order to streamline the process. I think for those areas, for instance, of litigation where you know that claimants don't like being in front of the court, they want to sit back, they'd like not to have any adverse cost risk, for instance, where you've got a limitation issue on the book build and you can then stop the limit time running and then gives you a chance to book build in the background. Those sorts of situations are ones where I think the 19.6 route, the bifurcated 19.6 has a real benefit. And I can see that being used a lot more as creative people get their heads around it.
Anything to add on that, Victoria?
Oh no, the true experts have spoken.
Okay, well, with that, are there any questions? I appreciate we've only got a few minutes left before the coffee break, but if there are, please. There's a question down here. The microphone is coming. Wouldn't mind introducing yourself before asking the question.
David Green, Edwin Co, and also co-president of the Collective Redress Lawyers Association, newly formed, for those on the claimant side. I just wanted to ask about distribution of the proceeds and what effect that has on carriage disputes, other issues, indeed whether the certification at all, about plans of distribution of the proceeds, for instance, to consumers.
Shall I go first? Well, we know because of the Supreme Court judgment in Merricks, of course, that distribution is generally to be thought of at the end of everything, and that the CPO judge can have regard to it, but it's really not meant to be a central consideration. Now, in a carriage context, I think at the moment, all bets are off, because certainly our experience in FX is they can crawl pretty much wherever they want to crawl to. And so it may well be the case that if one proposed class representative has better plans than another one, that could be taken into account. But of course, the reason, a principle why this is all to be properly ventilated at the back end, if I can put it that way, is that the core principles are justice and proportionality. And until you know how big the pot is, you can't really say anything extremely sensible about either of those, and of course, everything is capped by your best possible world, I suppose. So if you know that even if you were to be victorious on everything, you still wouldn't do anything other than a per capita distribution, you probably should say that at the outset. But I think it's perfectly respectable to say we can't say anything at the moment. These are some ideas, but we'll come back to you in due course. And of course, as we all know, the CAT has total power over distribution. You make your proposals at the end, but it's the CAT who case manages it and who can make directions that, even as to the formula that's applied or to whom they're paid, everything like that.
Yeah, I mean, the idea that that's another factor that might hit us on a carriage fight is terrifying. But I mean, at the moment, people are putting distribution plans forwards as part of their applications, and it doesn't seem to be getting a great deal of airtime. So far, so good. And of course, on the opt-in cases, we're perfectly used to dealing with distribution without any form of support from the court necessarily at all. And provisions in litigation management agreement, claim management agreements that allow for committees to allocate damages between the group in a fair and equitable way, sort of Robin Hood clauses that allow distribution from some to others where that would be appropriate or just. So, as I say, the market's been doing this privately to try to fashion a remedy for people. How the CAT then takes that forward, and that'll be up to them, and that's for another day.
Yeah, one of the interesting aspects of Le Paterel, where we just had the decision from the Court of Appeal, of course, is that addressed crediting accounts as a way of distribution. So the BT case, they're all account holders anyway, and BT, if it loses, the claimants have said one of the things that BT could do is simply credit off the damages. Now, you may be thinking, well, that will mean there are no undistributed damages. And I explained earlier that the funder's return comes out of undistributed damages, but there'll be total distribution. And this was the passage I was referring to in my presentation earlier, that the Court of Appeal says, well, actually, this isn't a problem at all, because in an entirely unreasoned paragraph, essentially, it says, well, it would be possible for the CAT to say, well, the funder's return comes out first, and then everything's credited off. Now, I don't see, I'm afraid, how that's compatible with the legislation or with the rules, but what it does mean is that we have this very authoritative, from Lord Justice Green, unanimous Court of Appeal, very pro-funder judgment, pro-funding judgment, so we see that same kind of liberalising pro-funder force that we've got in our Supreme Court decisions, now in the Court of Appeal saying, no problem, if the claim couldn't be brought without funding, as it can't, and if a funder won't bring a claim if it can't get a return, as it won't, then the tribunal can do whatever it needs to do to make that commercially attractive, essentially. So a kind of remarkable paragraph in the judgment.
And in a way, it also presents opportunity, right? Because one of the things that funders are concerned about, because you only get paid out of the undistributed pot, is what's the take-up rate going to be by the claimant class. That's now, if you look at other jurisdictions, especially when you have a class of consumers, that's been historically extremely low. So to the point that this rule hasn't really put off funders so far. But you can totally see that changing as, with technological advancements, right? It can be easier to bring damages awards to the notice of the class, easier to distribute it in a BT, they don't even have to make a claim. You can just directly credit it to their accounts. So in some ways, I think it's a good thing if there can be flexibility about the order of distribution, and that could mean that whatever happens with take-up rates and technology in future, funding remains available for these sorts of cases.
Thank you. I have a big sign telling me that I'm 2 minutes over my time, but the beauty of that question was that it actually took us to the topic that I skipped over to allow time for questions, so thank you for that. I'm sure the panellists will stay around for the coffee break if there are other questions, but otherwise, just like to thank everybody for their time, sharing their expertise with us this morning.